Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. Now, in today's podcast, we are going to be talking squarely about estate planning and elder law today, and specifically the Secure Act. Now, just a reminder for all of my listeners, please do not take information that you hear from this show or any other show for that matter to constitute legal advice. If you are looking for legal advice, please contact an attorney licensed in your state in the area that you are looking for so that you are sure you are getting the best possible legal advice that you can in the given situation. If you're in Pennsylvania, please feel free to reach out to us at Bellomo Associates, www.bellomoassociates.com, or give us a call at 717-845-5390. We would be happy to assist you. At Bellomo Associates, we provide free educational workshops. They are in the area of estate planning, crisis planning, special needs planning, and administration, probate and trust administration after the death of a loved one. We would be honored to provide the education to you and your family so that what happened to my family does not happen to yours. Now, on today's episode, I want to really dig into the Secure Act. And if you're sitting there thinking, I don't even know what you're talking about, I'm not surprised. And the reason for that is because the act was passed on December 23rd of 2019 at, I believe, around 3:30 in the morning. Don't quote me on that, but it was in the middle of the night. Now, why do we tend to pass things in the middle of the night, especially on Christmas Eve? Well, usually it's because you don't want a lot of people to know about it, and you don't want people to push back or to have any backlash. So you do it around a holiday and then another holiday coming up, and the chances are most people won't really realize what occurred. And that is exactly what happened. Now, the problem is, for people who already had planning based upon the old act, we have to update documents. So I'm going to talk a little bit about what the Secure Act is, what it does, and why we need to get documents updated that were done prior to the Secure Act. All right, so let's use just a basic example. If a parent left a retirement account before the Secure Act to a loved one, to a child, for example, we were allowed under the old act to do what was called an inherited IRA and make the beneficiary of that IRA a trust for the benefit of the child, or, for that matter, the benefit of the spouse, and still get the same stretch out expectancy over their life and allow us to get asset protection. So what it allowed us to do is to use the person's life expectancy, stretch it out over their lifetime, and keep it in the trust over the person's lifetime to get asset protection. We did that in a trust called an accumulation trust. Now, that just means nothing more than allowing us to leave it in the trust for asset protection from car accidents, long-term care costs, divorces, nursing homes, right? All those kind of things, the assets were protected. We still got the same stretch out tax benefit, and we were able to get the asset protection. Now, things have definitely changed, unfortunately. So, just straight tax consequences. If a child were to inherit under the old act, then what would happen is, let's say you're, 40 years old, and I'm just making up a number here. Let's say the life expectancy for a 40-year-old was 42 years. You could stretch out $1 million retirement account over the child's life expectancy, right? So let's just call it 42 years. You're stretching out $1 million consequence because remember, the taxes have not been paid on that yet, and you could stretch it out over 42 years. Not a big deal. Pretty good consequence. And we were allowed to leave it in a trust for full-blown asset protection planning. Those were called see-through trusts. So it allowed us to get the same tax benefits and use an accumulation trust to keep it asset protected over the child's life expectancy. Now, In 2019, with the Secure Act, what it now says is that spouses are allowed to stretch it out over their life expectancy, but children have 10 years to pay it. 10 years. So that means now you're stretching out $1 million tax IRA over 10 years. So that could be adding $100,000 of ordinary income to a child's tax bracket. Now think about it. Who is probably in a lower tax bracket? The child in their highest wage earning years, their 50s and 60s, or the parent in their 80s, maybe 70s, 80s, 90s, fully retired. Well, generally speaking, the higher tax bracket is going to be the child in their highest wage earning years. So prior to the Secure Act, it was all defer, right? You want to stretch out and pay the taxes as long down the road as you possibly can. Nowadays, it's not necessarily the case. Now I'm seeing a lot of financial professionals, both advisors and accountants, starting to tell clients, look, you don't want to wait anymore. Once you're fully retired, you're over 59 and a half, and you're not working and you drop to a lower tax bracket, you might want to start considering stretching that out over several years, maybe your life expectancy, right? Stretch it out over years so that you can start to bring down the amount that has to be taxed to your children in just a 10-year period. It is definitely a shift in thinking. I've had several people say to me, we were always taught our whole life to defer. And now, these advisors and accountants and lawyers are telling us maybe not. Well, that's what happens when the law changes. And unfortunately, that is a huge consequence to the Secure Act. And then it gets worse, right? Remember, under the old act, we were allowed to be able to stretch it out and get the asset protection. Well, now, not only can't we stretch it out really over the child's life expectancy, but for the spouse and the child, we must use a trust that is called a conduit trust, which means any portion that the individual is paying tax on that year has to come out of the trust, which essentially means that for a child, at the end of the 10-year period, you are losing the asset protection because all of the money must come out every year over the 10-year period. And at the end of the 10 years, then, you ultimately have everything out of the trust. And that's regardless of whether you can take it all at one time or whether you have to take it out equally over 10 years. By the 10th year, at the end, it will have to all be out of the trust, which means we lose the asset protection on the retirement account. And for a spouse, we also have to use a conduit trust and can no longer use an accumulation trust, which means that we have to make sure that we take out the piece that the person is getting every year as the life expectancy and take it out of the trust. Again, losing asset protection. Now, with a spouse, we're going to lose it potentially at a much slower rate because we're able to do that over the life expectancy of the spouse. But we're still having to pull it out. And the last comment that I want to make in this regard is that we have got to change all documents that are currently in place that have trusts listed as the beneficiary of the account, right? So if you have a retirement account and you named a trust as the beneficiary of it, which was very common under the old law, right? It was extremely common because you could get the same stretch out and you can get the same tax consequences. Now, especially after, 2.0, Secure Act 2.0, and all the regs that have come out, we are now having to redo all of the documents for people who named the trust as the beneficiary. Now, one thing that we have done for a long time, is we have named the spouse outright as the backup, meaning you name the trust first, the spousal only retirement trust first, then the spouse outright. You name the separate share trust for the children first, then you name the children as the backup, right? Outright. And the reason that we always did that is because we were making sure that if the laws ever changed, that we would have an out, that we would have a backup. After the death of an individual, we have a disclaimer period, okay? Which means we've got 9 months to disclaim a portion that we're going to receive. Or say no thank you, right? I don't know how else to say it. So just, we're going to say no thank you, but we do have a time period in which we must say it. And then it goes to whoever the contingent beneficiary is. Well, if the contingent beneficiary is the child outright, now we're able to get it to the child, stretch it out over the 10-year period, and just have the child get it. Or if it goes to the spouse, it would go out over the spouse's life expectancy and not in the trust. Unfortunately, not everybody did name the spouse outright or did name the child outright, and now there are some negative tax consequences that are occurring after the 2019 Act, specifically after the regs came out and 2.0 came out and clarified several things. So what all of this means is, if you have a document that you remember naming a trust as a beneficiary of a retirement account, please go see your attorney. Please go see your advisor. Please remind them that you do have a trust name so that they can update it. We have all the updated language. We have reached out to all of our clients, but unfortunately, not everyone responds. Not everyone comes in. And in the past, with most changes, it was one of those, it is what it is. We'd like them to change it, but if they don't or they can't, we're not going to stress about it. Now it's a very different ballgame because we always used accumulation trusts. Of course, because that provided the asset protection and the same tax benefits. Now we have to switch them to conduit trusts, and if not, it is giving a negative consequence. Gee, Jeff, what if I don't have the spouse named outright as the backup, or I don't have, a child named outright as a backup? Well, I would get that updated too. Even if you have the new language, every now and then we have a financial institution that doesn't want to do the child outright as the backup or the spouse outright as the backup. And I think that is just because they don't understand it. It doesn't make sense to name a trust first and then name somebody outright. But the reason that we do that is because a trustee of a trust can disclaim, and it's not considered that the person is doing something individually. So let me explain. If the individual is named first and they disclaim and then they need long-term care immediately, the state is going to say, no, you can't disclaim an interest that you received individually to make it go somewhere else so that you qualify. But if the trust is named and the trustee is acting as the trustee of the trust, even if it happens to be the same person, they are acting in a fiduciary role. A fiduciary role means that they are held to a higher standard, that they are sitting in a much higher position, and that they must act in the best interest using that role. So if you're the trustee is going to act as the best trustee that he or she can be, and that they're going to do their job in the best interest of the trust as the trustee, regardless of maybe they will end up benefiting from it, and maybe it will go outright to them, or maybe it will go, to them through the estate or whatever. The truth is, they're acting as the trustee and can disclaim. Whereas if the individual disclaims, that would be considered, basically an uncompensated transfer for long-term care purposes, for Medicaid purposes, and there would be a penalty assessed. But not if the trustee of the trust disclaims, and then it just goes to the individual. So this is a long-winded way of saying there is a method to the madness, and if your attorney or professional asks you to name a trust and then name an individual outright afterwards, please do so. And if you happen to be the financial institution accepting the beneficiary designations on the back end, I urge you to accept the spouse and the child outright as the backup, because there is a reason why we do it. It provides flexibility at the time of death. One of the ways that I like to say this is it allows us to make a game time decision, meaning at the death of the individual, we're going to look at the beneficiaries, we're going to look at the law, and we're going to decide what is the best thing that we should be doing at this time based upon the law and based upon who the beneficiaries are. And we won't know that until the person who owns the account passes away. That is a game time decision, which means we need contingencies. We need backups, which is why we're going to do outright. The biggest takeaway that I just want to make sure that I reiterate one more time is that if you have a trust as a beneficiary of a retirement account, please contact your attorney. Please contact your advisor. Please, 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 right? Because leaving the document the way it is can cause your family negative tax consequence that it doesn't have to otherwise. If you get a letter from your attorney, if you get an email from your attorney, please read it. Please get into their office. Please take care of it. I cannot tell you how many people we have sent notices to and we've not heard from. And we're just doing our best to get through everybody, but it is much easier for you to reach out to your attorney if you get a letter, because there's a reason why we're sending it. There's a reason why we're asking you to please update the documents. To all the advisors out there, if you know that a client of yours has a trust listed as a beneficiary and you think that it might have been done before 2022, 2020, beginning of 2023, reach out to the attorney. Have them take a look and make sure that the language that's in there meets the Secure Act. The language wasn't able to be changed immediately, and then we did get changes, and then we had to make more changes once 2.0 came out, which was really at the beginning of 23. So it hasn't been that long that we've had the new language that we need, and we need to get the documents updated so that we're not causing negative tax consequences because we named an accumulation trust versus a conduit trust, which was great planning under the old law, which made complete sense under the old law. But now we have to get them updated, which also brings me to my point of making sure that you're staying in contact with your lawyer at least once a year. I remember years ago, I would say every 3 to 5 years, and then I went to every 1 to 3 years, and now I'm saying at least once a year. Not only do we have the issues with the Secure Act, but other laws have changed, and we've also seen banks and financial institutions telling us that they do not want powers of attorney to be more than a year old. Right? Now, I know that sounds burdensome. I know that sounds overwhelming, but the truth is it's probably really good practice now to just start getting your documents updated once a year, whether things change or not, whether your family dynamics change, whether your wishes change, whether the fact is laws are changing, interpretations are changing, what people are expecting is changing. So we need to make sure that we are staying on top of that and making sure that we're not allowing it to get to a point where things are getting stale. At Bellomo Associates, we offer the Red Wagon Club, which is an opportunity for families to enroll at a very low cost and get changes as often as they want because they want them or because the laws change, right? So now we are bringing in hundreds and hundreds of family members for the Secure Act changes, as well as to get all of those powers of attorneys updated. So there's a lot of work that goes into getting that done. Certainly, it's a lost price leader from the law firm's perspective, but it is wonderful for the client and getting them updated on a regular basis, and also seeing your clients on a monthly basis for all of the speaking engagements that we have, the picnics that we have. It allows them to become part of the family, and they are referring 3 times more than anyone else. So it is our best sort of referral source, but also it's part of our family. So even though we lose money on the front end, it works out great for the client because they get documents that work when they need them to, and it also works out well for us as a law firm because we do get that trust, the family relationship, and referrals. So it is important to make sure that you're getting your documents updated on a regular basis. And also, in light of the Secure Act, if you named a trust as a beneficiary, please, please, please get that updated. Please get it taken care of so that you can change it pursuant to the language of the Secure Act as well as 2.0. So that's today's public service announcement. Please see your lawyer to get your documents changed if you have a trust as a beneficiary of a retirement account. If you're not sure, reach out to your financial professional and your lawyer to see so that they can check it. If you happen to be a client of Bellomo Associates, please give us a call. We have changed all of the languages in the last couple months, and we do want to make sure that we get you the new language so that it doesn't cause a negative tax consequence to you and your family. I would really like to thank you for joining me on the Red Wagon Estate Planning and Elder Law Show. For today's episode of the Red Wagon Estate Planning and Elder Show, where we talk about all things estate planning and elder law, and well, hey, anything else we want to talk about. Now, on today's podcast, we talked about the Secure Act. We talked about what it did. We talked about how it doesn't allow asset protection for the lifetime after death, and how we do have to force the distributions out now using a conduit trust instead of an accumulation trust. The biggest takeaway of today's podcast is if you have a trust as a beneficiary of a retirement account, please call your lawyer, please call your financial professional, and get yourself an updated document with new language. Trust me, even if you have to pay a small fee to get the changes, it will save your family a lot of money on the back end because it won't cause the negative tax consequences that the current old documents would. So you want to get those updated. Thank you so much for your time today on the Red Wagon Estate Planning and Elder Law Show. I'm Jeff Bellomo, and until next time, we'll see you real soon.